Okay, so we have the chapter 6, which talks a lot about the school personnel and school district liability and all the different cases that we're going to see here. So it should be noted that teachers and administrators are held to a higher standard. So we have a duty of care that we owe to our students. The teacher or administrator is under the duty to possess more than the ordinary amount of intelligence in relation to students and their care. One word that's going to come up quite a bit here is the word torts, which was kind of a new word for me, but it's an actionable or civil wrong committed against one person by another, independent of contract. So educators commit a tort when they violate a legally imposed duty that results in injury. So a couple of examples here is a teacher forgets to supervise recess. We're going to be looking at some negligence there. If a coach pushes or assaults a kid in frustration during a game, we have an intentional tort because they made physical contact, and a principal spreading false rumors. We have a defamation lawsuit. So you're going to see a lot of those things as we get going through this chapter as we talk about it more.
So the school as a safe place, schools are presumed to be safe places where teachers teach and students learn. This view is held by the courts is that professional educators acting in a place of parents are supervising students under their care and ensuring the greatest extent possible and that they are safe. So basically what we read about for this was that educators have three legal duties in place of when the parents are not there, which is to instruct, supervise, and provide safety. And the school has the responsibility to take action or be liable for those things, all of those things.
So liability of school personnel, schools have this responsibility of their own torturous acts in the school environment. This means that principals, teachers, or other people that work at the school can be liable for the torts or if they inflict these torts on students, and lawsuits can occur. And there's unintentional torts and intentional torts, which was also like new terminology for me too. Basically, what that means is, oh, I'll let you do that one. It's the next slide.
Yep. So intentional torts are assault, battery, libel, slander, defamation, false arrest, malicious prosecution, and invasion of privacy. They require proof or intent or willfulness. So I mentioned that one earlier, like a coach getting too physical with kids during practice or stuff. That is intentional because they are malicious about it and they are doing it with intent. So unintentional is where we're talking about negligence. So if we are just not doing our duty, sorry, I clicked there. If we're not doing our duty to our full potential, we are being negligent, and that's going to be unintentional. So we're not meaning to do it, but we are still liable for this.
Vicarious liability. So, since school districts are deemed employers of teachers, they may also be held liable for the negligent behavior of their employees. So, overall, basically, what this means is that the boss can take the blame. So, a family can sue the school, and the school district would be responsible because they hired that person, so they were responsible for their actions.
I always like to look at this one as like, because I did take a principal job this year, and like our duty of overseeing like special education law and stuff like that, like we are still liable, even though that we might not have. We have the duty to make sure people are doing their jobs and stuff like that one.
So foreseeability is a crucial element in liability cases, especially in cases involving negligence. Basically, this is where you know something can go wrong and you have to prevent that from happening. Um, Foreseeability is defined as the teacher's or administrator ability to predict or anticipate that a certain activity or situation may prove harmful for students. For example, there could be broken glass in the playground, and we need to take care of that before the students go out to play. or if it snows. I know that my principal in my school right now takes upon herself to go clean the snow before students come in and make sure that it's not a hazard for slipping. So, yeah.
So once this determination is made, there's an expectation that prudent steps be taken to prevent harm to students. So if we know about something, we have to take action. Failure to act on these matters may result in liability claims. One of the big ones coming up is like students making threats. If we don't act as administrators, but we know about the threat, then we can be found liable for not taking action when that was known. Make sure to do some of these things. We have to make sure as an admin that we are making announcements, like Erika said, of cleaning sidewalks, making sure all that stuff is taken care of so kids aren't having hazardous school environment.
Assault. So an assault is an offer to use force in a hostile manner, which causes apprehension. The person being assaulted normally must feel a degree of immediacy in the sense that one committing the assault will execute it promptly and has the apparent capacity to do so. This means that it's a threat to inflict harm. And even if you are fearing your safety or think that it might happen, that can also be part of assault.
Battery, this is when there's physical contact that takes place. That in practice is a battery is a successful assault. Battery involves unwelcomed and unprivileged body contact involving another person that is hostile and unlawful. This is physical contact, can be threats or threats that turn into action with hitting or fighting in schools.
So assault and battery affect teachers, administrators, and students in the school environment. Every person is responsible for his or her actions involving assault and battery claims. I feel like this has been a lot more present, especially like you hear about it in elementary schools where kids are throwing desks and throwing chairs and stuff like that. And that's where it gets really like scary on that kind of level. Cause I mean, we're getting into, there's laws been passed in Nebraska where you can't suspend a kid under a certain age, and these assault and battery things are truly foreseeable if we know a kid is throwing and hitting and doing all this stuff in our classroom. So it's our responsibility there to make sure we understand all that stuff.
Defamation. Defamation occurs when false statements are made about a person. These statements are generally made to tend a person's reputation or their name, and it is subject to like hatred or any of those sort of things that would be made to hurt another person or their reputation.
Certain statements are privileged if made in good faith and within the scope of the educator's duty. So, people who, like school personnel who expect to be protected by qualified privileges must not take false statements or regarding students or colleagues with malice or intent to harm. So we have to be very careful about like how we speak about other students or staff members to other students or staff members. Just always be ethical with your conversations and make sure that if it's private or just I don't know, probably just not say bad things or rumors. I think a lot of our teachers like to vent with this one, and it could get us in a lot of trouble.
So libel and slander. So you're going to see two different types of defamation things. So there are two types. Libel is written defamation. So this would be, we see this a lot with emails or like Facebook posts, things like that, where it's actually written stuff. And slander is just oral defamation. So that's like through verbal communication. Both include statements or communication that result in injury to a person's reputation, good name, or standing in the school or community. One of the most interesting things I thought about this part of the book is a lot of things they said come out of these. If the person can prove libel or slander, then most of the time it comes out with monetary damages. So you get a lot of money coming out of those court cases there, which can be kind of scary. An example here, a student posts on social media that a teacher is a criminal when it's not true. This is libel because it's written. A student spreads a false rumor in a hallway that a teacher was fired for stealing. This is slander because they're just talking about it. Libel lasts longer because it's written down, but slander disappears after it's spoken, but the damage can still be very, very serious.
A third party must be privileged to this communication to establish defamation. The burden of proof rests with the person who claims injury based on defamatory statements. Defenses against defamation include, there were three types that we read about. So that was privilege, which is you are allowed to say stuff even if it harms another person's reputation. You have your right to say that. The second one was good faith. What you were saying, you really thought it was true. And then the last one is truth. If it is true, it is not necessarily defamation.
False imprisonment. False imprisonment occurs when a student is detained illegally by the teacher or the principal. False imprisonment is considered to be an intentional tort because the teachers and or principal know that the student is being detained for a long period of time without malice or reasonable suspicion.
Unintentional torts is a wrong perpetrated by someone who fails to exercise the degree of care in doing what is otherwise permissible. Example, acts of negligence. So negligence is perhaps the most prevalent source of litigation involving injury to students. One thing that this kind of reminded me of is I am a science teacher. So at the beginning of the year, I do have to go over all my lab safety stuff. So all the kids know what's expected. They have to sign a safety contract. They have to take a quiz over all this stuff. So I'm proving that I have actually went over all this stuff before they can participate in any labs. Yeah.
Negligence is generally viewed as the failure to exercise a reasonable standard of care, which results in harm or injury of the person. Most negligence cases involve civil wrongs, although there may be instances in which the accused faces both civil and criminal charges. Basically, this is saying that the liability needs to meet four criteria, and these are the things that they look for to decide if you are legally responsible. So those were standard of care, which is what should have the teacher done. Breach of duty, did someone not do their job? Proximity of legal cause, did the mistake cause harm? And then injury, was someone hurt by what happened?
Standard of care is an important concept cases involving liability of school personnel. It requires that school personnel exercise the same degree of care which a person or ordinary prudence would exercise under the same or similar condition. It's basically saying that, you know, we as teachers and caregivers need to keep students safe and provide them with the same care that their parents entrust us with. And this it also says that educators are expected to exercise reasonable judgment when dealing with students and when they're under our care and protection.
This standard of care will vary depending on particular circumstances. The level of care due students changes based on the age, maturity, experience, and mental capacity of students, as well as the nature of the learning activities in which they are involved. The elementary students, if you go on a field trip, you're going to have a lot more people supervising than if you take a handful of high school kids. I mean, we have to consider the age and maturity of these kids, the level at which they're at. If we're taking a class of special needs kids onto a field trip or something, we have to make sure we have all their accommodations. So we have to make sure we're doing our due diligence before we do any of these things, so we know what we can do to keep the kids safe.
Defenses for negligence or contributory negligence. If the evidence reveals that the person claiming injury exhibited conduct that fell below a reasonable standard, liability charges against school personnel may be dropped. And that basically means that if the person was being careless, they might not be able to sue the school.
Assumption of risk. This is when the defense or the person or student or family situation involves various types of contact related activities like athletic teams, pep squads, and certain intramural activities. This is we read like a case in our book where there was a student that convinced the janitor to let him play basketball off of like school hours, and the janitor let him in, and then the student got hurt, and then the student came back and tried to sue the school for um, because it wasn't a safe situation and the game should have been supervised. But then the assumption of risk the students were taking was that it was off of school contract hours and there isn't staff to be able to take care of them while they were playing this game. So the case was not responsible. The school was not responsible for this situation.
So even though a student assumes an element of risk, it does not relieve school personnel in cases where they fail to meet a reasonable standard of care based upon age, maturity, risk, and nature of risk associated with the activity.
Comparative negligence. Under comparative negligence, act of those responsible compared in the degree of negligence attributed in an injury situation. Basically, this means that they're going to look at if both the school and the injured person are at fault, or if they're going to split the blame depending on what happened. So, an example of this might be if a teacher leaves a puddle of water on the floor and they know that it's there and they leave it, and a student runs through the hallway, but they were texting while they were running, both people are at fault. So they would split the blame on what happened.
And immunity is a legal concept that diminishes in terms of impact, and it's based on the old common law of sovereign immunity. The king can do no wrong, meaning that the state or federal government is protected from suits and cannot be held liable for injuries that result in the proper execution of governmental functions. So schools have governmental immunity, but they can still be sued for situations that come up with all of these things that we were talking about in our slide today.